So we're going to start this discussion with the third issue. And we're going to hear from Professor Arti Rai, Duke Law, one of the nation's leading intellectual property law experts, but also someone who has extensive public policy experience. She was a senior official in the Patent and Trademark Office in the Obama administration. Arti?
So thanks so much, Steve. Can everyone hear me? All right. I've been told that I have a loud voice, so apologies if that bothers you. So thank you, Steve, for that kind introduction. And Steve has already alluded to the fact that I'm going to be talking about patent-eligible subject matter or patentable subject matter as shorthand for what the Supreme Court has done with respect to Section 101 of the patent statute. I think it's fair to say that with the exception of the America Invents Act, which Steve's report for the National Academies was crucial in setting the blueprint for, these Supreme Court cases have been the most important substantive patent law change in the last few decades. They are the 2012 case of Mayo versus Prometheus, the 2013 case of Association of Molecular Pathology versus Myriad, and the 2014 case of CLS Bank versus Alice. CLS Bank versus Alice I will focus on less today because it is a pure software case. That said, the so-called Mayo two-step that was enunciated in Mayo was also adopted in Alice. So we have a uniform standard, if you will, for what constitutes patent-eligible subject matter. It may not be a clear standard, however, and that is part of the challenge. And that is why Senator Coons and Senator Tillis had hearings last month on the question of whether Congress needs to step in, because the Supreme Court, since its 2014 decision, has not seemed to be inclined to revisit the issue. It's denied certiorari, if you will. Certiorari is the petition that one makes to the Supreme Court to get one's case granted in a large number of these Section 101 cases, and just for a variety of reasons appears to think that it would be better for other branches of the either the judicial system or the legislative system to work this issue out. Okay, so let me start with my bottom line preview of what is a very complex topic, because it gets into the weeds of patent law, and I apologize for that, because some of you may not be so excited to know about the weeds of patent law. So I'll start with the bottom line preview. The Myriad case, which was probably the case that got the most public attention for a variety of reasons that we can get into, I think primarily because it was related to breast cancer, and breast cancer generally gets a lot of attention, I think has had relatively little impact, and the data, to the extent we have data, suggests that as well, on drug patents or otherwise. So perhaps ironically, the case that got the most media attention is the one that's probably had least impact, at least certainly on drug patents, but probably otherwise as well. The Mayo case, the Mayo versus Prometheus case, the 2012 case, which was explicitly reaffirmed in Alice. Alice did not mention Myriad, which is really interesting because it was decided only 1 year after Myriad, has had, I think, a much more significant impact, and I think it is where Senator Coons and Senator Tillis are particularly interested in thinking about Section 101 issues. In fact, when they had the hearings last month and the question of gene patents came up, they said, oh, no, we don't have any intention of discussing gene patents. That's not really what we're talking about here. So that's the bottom line in terms of what I think the impact of these cases has been. Now the normative question of the bottom line on the normative question. I think the normative question is really interesting on Mayo. I think it has had some positive impacts and some negative ones. So I would take a middle road on the set of issues raised by Mayo, and I will talk about now why I've reached that conclusion with respect to Mayo, and also just briefly talk about why my conclusion with respect to Myriad is that at the end of the day, it hasn't had a very significant impact, at least in the drug patenting space, and perhaps more generally as well. So, as we've discussed already, drug patents under Bayh-Dole are really interesting because it really depends on what sort of drug patent you're talking about. This came up in the first panel. People disagreed quite vehemently about whether patents are actually an indicator of innovation at all. And I would absolutely agree with that. It really depends. It depends on what the patent covers. Some patents, I think, are clearly not an indicator of innovation. And that's where all the evergreening debate arises from. And as a consequence, it's really hard. And that's unfortunate because hard questions are tough in general to deal with, and certainly for Congress to deal with. But I think that's the really important question. What precisely does constitute an evergreening patent versus a non-evergreening patent? Because one person's evergreening patent can be another person's somewhat innovative precision medicine, and that is the most important controversy to resolve. And that is regrettably, I think, not something that the cases resolve or that Congress, at least in its hearings thus far on patent-eligible subject matter, appears inclined to resolve. So in order to discuss how all these issues relate, let me just recap Mayo and Myriad. So Mayo substantially fortified the so-called law of nature exception to patent eligibility, and Myriad the so-called product of nature exception. I've already suggested to you that I think at the end of the day, Myriad has not had that much of an impact on drug patents, and this is the reason. Myriad, for those of you who know a little bit about it, involved, as you know, or you probably know, the breast cancer diagnostic patents. And so you might ask, well, why would it have had any impact on drug patents at all? And that's a fair question. The reason people thought it might was because of a technical distinction that was drawn between cDNA and gDNA. And we can get into what all that means in the Q&A if people want. But as a consequence of the technical distinction, some people thought, myself included in a paper in Science I wrote with Bob Cook-Deegan in 2013, that maybe isolated and purified products of nature, which can include drugs, might not be patent eligible. It hasn't turned out that way. It seems that for the most part, patent lawyers are able to draft claims that look like they get around the Myriad bar for the most part. And so I'm not going to talk more about Myriad for present purposes unless people want to in the Q&A. So what about Mayo? Mayo is, interestingly enough, also a diagnostic patent case, although some would call it an evergreening patent case. Let me explain. So it was a case involving maybe, depending on your point of view, precision medicine, or maybe not. Maybe it was the right drug for the right patient at the right time. It was a mechanism, it did cover a mechanism for measuring a metabolite of a drug to ensure that one didn't give the patient too much or too little. Is that innovation or is it evergreening? Unfortunately, the Supreme Court didn't really answer that question. It came up with this two-part test that says instead, going back to some 19th century jurisprudence, which I think is best forgotten, unfortunately, the Supreme Court decided to resurrect it. Well, let's look to see whether there's a law of nature. And if there is, then let's look to see if there's an inventive step beyond the law of nature. Well, that's just a mess. I think that's a very well-accepted view of Mayo, that it just does not clarify anything. Now, the patent in Mayo might well be evergreening because it's not, or it is obvious. It's not non-obvious, to use the garbled lingo that patent lawyers use. And that's a problem with the patent, but that's not a patent problem with patent-eligible subject matter. And so the concern with respect to what Mayo has done is that it might sweep away a lot of precision medicine. Mayo itself may have been an ever-grieving patent, but if precision medicine relies deeply on new laws of nature. Oh my God, 30 seconds. Okay, what are we going to do? Okay, so, so I think at the end of the day, the Mayo shortcut is, in general, a bad thing. It does probably sweep away some evergreening patents, but it probably does so in an over-inclusive manner. Now, fortunately, it does seem that even without the Supreme Court weighing in, the Federal Circuit has done some things to take the edges off Mayo. So method of treatment patents are probably okay under a case called Vanda that was handed down last year. And so we will see. It's the PTO, and this is the work that and the empirical work I've done with Colleen Chan, appears to be getting a lot of these patents and even granting some of them. So that's interesting. And so maybe we're underruling the Supreme Court. In other words, we can't overrule the Supreme Court, but we can underrule them, and maybe that's what's happening here. Now, finally, I'm going to get almost within the 30 seconds. Back to the publicly funded research theme. If Mayo isn't the way to get rid of evergreening patents, and I think on balance it's not, is there a better way? I've argued in a lot of my work that the PTAB is the better way. That's what the institution that's supposed to deal with non-obviousness. And I'm very happy that Senator Hatch's attempt, former Senator Hatch's attempt to exclude the PTAB from drug patents never got off the ground. And I hope it never does, because it seems to me that the PTAB is the way to go. And that's how we should be dealing with evergreening patents. So thank you.
So I want to give, since all the panelists are expert in areas they're not talking about, I want to give them a chance to weigh in. Jay, do you have a comment on Artie's presentation?
Yeah, why not? Thank you, Steve. So what the U.S. courts ought to be doing when they look to patentable subject matter issues is to look at such things as the pace of innovation, what are information sharing norms, are other intellectual property rights available, like trade secrets, or a right that pretty surprisingly hasn't come up yet at all at this event, which are regulatory exclusivities administered by the FDA. By the way, there are biologics. There is a directory of biologics. It's the Purple Book. It lists the regulatory exclusivities, and there's 2 pending bills in Congress that would cause for a listing of patents under different circumstances. What's the rate of industry concentration? What are the patterns of enforcement in that industry, which is a polite way of saying, are there trolls? Okay, are there other professional incentives for innovation? Those are the sorts of things we ought to do, whether we decide broad swaths of industry ought to be exposed to the patent incentive. But we don't do it, and Congress and our courts can only deal with the statute that Congress has given them. So I'm hoping for some sort of legislative fix. I think it's the only way out.
Anyone else?
That one. Okay. So certainly, I think within the university community, the perception is that it is now extraordinarily difficult to get patents on novel diagnostics. What the impact that will have on the establishment of new venture-funded diagnostic companies remains to be seen. On the other hand, we do have the example of Foundation Medicine, which it was a diagnostic company, has gone on and it was acquired for a very considerable sum. But diagnostic seems to be a big issue.
So I just want, can I respond to Jay?
Absolutely.
Okay. Which one is it, this one?
Yeah.
Okay. So, Jay, all of that very sophisticated economic analysis is not, I fear, in any of the bills that I've seen. B, I'm not sure courts could deal with it. So maybe the economists can, but courts aren't composed of
And I
economists.
trust courts do it all the time.
And how well is another question.